of the media. Welcome to this urgent Central Committee meeting number 38 of today, Friday, July 8, 2022. We've established a quorum of 9 members. Please let's stand for a moment of silence. I've received notice of absence from MP William Marlin. Is there any member of Parliament who wishes to have the floor for notifications? I see no need. Members of Parliament, the recess of Parliament officially started, as you know, on Monday, July 4th, 2022, and it goes until August 12th, 2022. During a recess period, Parliament generally does not have any meetings or committee meetings. However, due to the need to handle several urgent matters, I deemed it fit to call members back to the House of Parliament to handle these urgent matters. We have then as agenda point, we have 3 agenda points today. The first agenda point is the letter from suspended Member of Parliament, Mr. Claudius Boncampo, regarding his suspension as Member of Parliament based on the articles of the Constitution of St. Martin. This can be found under IS 975, Parliamentary Year 2021-2022, dated June 3rd, 2022. The second agenda point is the National Ordinance amending the temporary National Ordinance COVID-19 cuts employment conditions for civil servants in connection with the phased reduction of the COVID-19 cuts employment conditions for civil servants. Parliamentary Year 2021-2022, number 161, again under IS 1123, 2021-2022, dated July 7th, 2022. And the third agenda point is the National Ordinance containing rules regarding the standardization of salaries of top officials in the public and semi-public sector, National Ordinance Standardization Top Incomes, Parliamentary Year 2021-2022, number 161. And this is also under IS 1122, Parliamentary Year 2021-2022, dated July 6, 2022. We go over to agenda point 1. On June 3rd, Parliament received a letter from suspended Member of Parliament, Mr. Claudius Boncampo, in which he addressed the matter of his suspension based on the articles of the Constitution. This document, again, is registered under IS 975 and has been shared with the members as well. In this letter of June 3rd, the suspended member states that considering that within the Dutch Kingdom only St. Martin applies this article enforcing suspension, and also considering that it is his firm belief that the international treaties regulating the rights of the senators to represent the people whom duly elected them are being infringed on. And he requests that the content of this letter be considered and duly realized. He also states that the suspension provision stems from a unique and awkward case that transpired many years ago in Curaçao, when a parliament who was irrevocably sentenced to 7 months of incarceration and couldn't attend parliamentary meetings. The senator in question asked every week to be released and transported to attend the Senate meetings. To prevent the recurrence of this circumstance, St. Martin introduced Article 50, sub 2 in its constitution. And without much thought about other possible unwanted negative consequences, the suspended member is of the opinion that in reading the explanatory notes of the articles in question in the Constitution, one can clearly establish the aforementioned. He continues and states that more importantly, this article was never intended to suspend senators who are 1, not irrevocably sentenced for one of the crimes mentioned in Article 50 of the St. Martin Constitution, and 2, not incarcerated and as such free to exercise their function without any impediment. The suspended member concludes his letter by stating that seeing that this is the second case of a member of parliament being suspended for these matters in St. Martin, while still fighting the case in the court of law, he firmly believed that it warrants a proper review regarding the manner in which the Constitution was prepared and if there were or any oversights like the right individuals have through the international treaties that govern this country and supersedes the Constitution of this country. It is important for me to note that the following, which stated during the public meeting of Parliament on January 6, 2022, that once Parliament is informed of such a situation based on Article 50, Paragraph 2 of the Constitution, the procedure is to initiate the process to comply with the provisions of Article 50, Paragraph 3 of the Constitution, namely the appointment of the substitute member of Parliament. It is recommended that Parliament acknowledge and determine on the basis of the information from the Public Prosecution Office that the Member of Parliament is suspended by law, which suspension occurs automatically based on the article in the Constitution. This declaration of the is of a declaratory nature now that the suspension is already in force based on the information received from the Public Prosecution Office. The declaration is important for both Parliament and other constitution bodies, and of course the community. There should be no ambiguity about the position of the suspended Member of Parliament. And based on the request of the suspended Member of Parliament, I would like the Central Committee to discuss this and chart a way forward regarding the request of this suspended Member of Parliament. I would like to suggest requesting advice from the Council of Advice regarding whether the clause of Article 50, Paragraph 2 of the Constitution infringes on international treaties, and if this proposal can be approved and forwarded to the public meeting for further handling. I'd like to now pass the floor to any Member of Parliament that would like to speak. I see that MP Bryson would like to have the floor. MP Bryson.
Thank you, Madam Chair, and good morning still. Good morning to my colleague members of Parliament, the Secretary General, the viewing public, those in the Tribune, and those following by other forms of media. Madam Chair, indeed, I think we've had two public meetings where we've discussed this issue of the suspension of a Member of Parliament, and in both of those meetings, the comments that you hear is that this is something that has to be looked into. I think we said that in the meeting, and let's say till now there hasn't been much follow-up, and that's either of our fault. I don't know if the government's looking into this or who's looking at it. But it's good to get the suggestion from MP Bonkamper to be proactive about figuring out this constitutional issue, I guess we can call it. But I do also think, in addition to your proposal about the Council of Advice, I think we have a Committee of Constitutional Affairs. Maybe that can also be referred to that committee where I think MP Bonkamper made a suggestion about having certain experts let's say chime in on this. If there is a need to I don't know if it will come at a cost or what we'll have to do. Maybe that can be discussed in the Constitutional Affairs Committee as well. Any such proposals can be made there. So let's say you want to hire a law firm to look at this situation. I don't know. It's not my suggestion. I'm just saying maybe in the Constitutional Affairs Committee, these type of suggestions can be made. Mention was made of Mr. Rutsel Marta, not the initiator, but the suspended MP himself. Perhaps an idea would be to invite him in a closed-door session to have discussions about that. But my main thing is, in addition to... Is there an echo or something? Somebody else mic on? Yeah. In addition to the suggestion that you've proposed, Madam Chair, I would like to suggest also that it's forwarded to the Chair Lady of that committee so that we can handle this topic as a constitutional topic. Another entity I think we need to hear from is the voting bureau, because remember what we stressed in that meeting as well. It is not the members of Parliament that suspend a member of Parliament. It is based on the suspension in the articles. We get a proposal from the voting bureau. We received that proposal on January 12, 2022, and the chair lady of that, or the acting chair lady, Ms. Natalie Tackling, who herself is an attorney at law, I think went into details on how they analyzed the situation and why the decision was made, or the justification for submitting the deputized member's name to Parliament. So the voting bureau has obviously probably done some research on this matter, maybe more than we have done already. So that would be also maybe within the setting of the Constitutional Affairs Committee to have the voting bureau also maybe see what they have found in their analysis of the application of this article. There was a document with some sort of analysis on that presented to the members of Parliament, which was attached to the review of the credentials of MP Brownbill at the time. This is IS 450 of the 2021-2022 parliamentary year. In preparation for this agenda point, I went back and read it, and indeed, it's not the typical letter that you get from the voting bureau where they just say, well, this is the person we're nominating. Actually, that document, I think it's about 8 pages, goes into quite some detail as to their analysis of that constitutional item and the reason why the deputized member is then put forward. So the voting bureau probably has done some research on this, and they should also be invited to the Constitutional Affairs Committee. So to summarize, have the Constitutional Affairs Committee decide if other external help is necessary, that proposal goes to Central Committee and to the Presidium, but that would be a viable committee to handle this topic. Thank you, Madam Chair.
Thank you, MP Bryson. I don't know from the top of my head, are you part of the Electoral Reform Committee?
I'm not in the Electoral Reform Committee, no.
Okay,
if I may, Madam Chair.
Yes.
I thought about that as well, and the Electoral Reform Committee, it's actually an ad hoc committee, if I'm not mistaken, and I think that was established for kind of a very specific purpose, which was to do with the electoral reform. This year has a bit to do with electoral reform, but I think it's more a very specific constitutional issue because it's a constitutional article that we're referring to in handling the suspension of a member of Parliament. So that's where I looked at both committees, reading the purpose of each. I think it's more fit for the Committee of Constitutional Affairs.
Thank you, MP Bryson. MP Bryson, so that we're not doing things redundantly, it was the last electoral reform meeting, it was already discussed and agreed that this would be one of the topics that will be handled through with a law firm. So we're busy creating a, yes. So I see MP Westcott, who is also part of that committee, that would like to have the floor, and I'll allow her to maybe elucidate as one of the members to maybe give more clarity on what the aim is there. MP Westcott, will you have the floor?
Thank you, Madam Chair Lady. A very good morning to you and our staff at Parliament. A good morning to my colleagues, and a good morning to all tuned in to this meeting. Madam Chair Lady, indeed, I ask for the floor to kind of bring forward that fact that this matter was discussed. I raised it in the last electoral committee, so the ad hoc committee for electoral reform. I raised this letter that at the time was in at Parliament, and I suggested that we give it some serious thought and review. Madam Chair Lady, the Article 50 in the Constitution, as I said during that meeting of the Electoral Reform Committee, there was a whole discussion when this article was inserted into the Constitution of St. Martin, whether such an article should go into the Constitution or the Constitution should create the basis for this particular matter, suspension, dismissal, etc., of members of Parliament, to be established in a lower law, a regular ordinance. Madam Chair Lady, at the end of the day, clearly it is in our Constitution. As it is right now, even before the letter, the contesting letter of suspended MP Boncampo, the matter as to how this article should be executed is nowhere further regulated. Madam Chair Lady, in the case when I was President of Parliament, just like you now having to deal with such a case, several questions have arisen in terms of, okay, who triggers what action? Who triggers what action? So as the article stands right now, these issues are unclear and have to be addressed. That's one thing. What I stated in the ad hoc committee electoral reform meeting that we had was that the point raised by MP Bonkamper in his letter, the points are very fundamental in nature. They go beyond the suspension based on X articles. You know, it's fundamental, and in my opinion, deserves to be looked into, reviewed, and Parliament needs to receive a clear view on that. Madam Chair Lady, in addition to the fact that in the Electoral Reform Committee, we have decided to address this matter as part of the overhaul of different articles in our Constitution, but I also support your proposal to get advice from the Council of Advice. May I suggest that before you send the official request to the Council of Advice, you have a discussion with them in terms of what exactly we're looking at. So I just wanted to add that to your proposal to have the Council of Advice advise. But again, I think we need to look at it. As I have stated publicly, I don't think that, while I understand it, I don't think that the matter of this deputizing for a suspended member of Parliament, I don't think it is helped by the fact that in that Article 50, the suspended member of Parliament continues to receive his or her salary. The question would be, what is being said with that? Is it then just an issue of not having the person here in Parliament? So again, there are some fundamental issues to me underlying this discussion, which we as a Parliament should definitely get some insight in and get some information from professionals, including the Council of Advice. So, Madam Chair Lady, thank you.
MP Westcott, are you suggesting that we discuss with the Raad van Advies, the Council of Advice, before handling it in a OV? Is that what you're suggesting, or?
Madam Chair Lady, if the intention is that this Central Committee proposes that it goes to the Council of Advice and then the Parliament can decide, we're going to ask the Council of Advice, we can do that formal part, can go through that formal part, and I'm just suggesting that you as chairperson of Parliament kind of explain to the Council of Advice, and you'll get some feedback from them, in terms of how far they are willing and will go in reviewing this entire matter. Thank you, Madam Chair.
Understood. Thank you, MP Westcott Williams. Next on the speakers list, we have MP Christophe Emmanuel. You have the floor.
Thank you very much, Madam Chair. Madam Speaker, good morning to you. Our Khafri, good morning to my honorable colleagues, our guests, individuals in the Tribune, and the people of St. Martin. Good morning to everyone. Madam Chair Lady, we as members of Parliament are co-legislators. And I have seen here where we have taken laws, we have taken articles, we have taken so many things and said we need time. I could remember vividly with a CFATF, I stand to be corrected, when it was, you better pass this or else. And the point that we stuck on was like, no, we're going to see whether it benefits St. Martin or not. And we took that piece and we took out what wasn't good for St. Martin. We amended, we adjusted, and we sent it back, Madam Chair Lady. And I listened to my colleague, MP Westcott, made mention as to the Honourable Member of Parliament who's suspended enjoys his salary, but simply can't be in the sessions in Parliament. But why is that, Madam Chair? Why is that? You read it out clearly. It simply came back to the time of Anthony Godet. So, Madam Chair, we here are suffering a lot for one individual, for a situation that they wanted to curb. We have to suffer it here in St. Martin. So I'm trying to understand the reasoning behind it when my colleague MP Westcott Williams made mention of she can remember when Article 50 came up, whether it should be inserted or not, I would have wished I was there to hear those arguments. Because, Madam Chair Lady, here you have the people of St. Martin voted for an individual. The individual has been convicted, has a sentence, and is in appeal, Madam Chair Lady. What if the appeal comes out and say not guilty? Then what? But even if that is the case, Madam Chair, the good gentleman still enjoys everything that comes with Parliament, for the exception of not being in Parliament. So right now, as we speak, Madam Chair, Parliament is paying 2 members of Parliament, so not 15 members of Parliament, but 16 members of Parliament. Madam Chair Lady, not only should it go to the Council of Advice, it should also go to the Council of State. In addition to that, Madam Chair, we was told, I always believed, that it takes a 2/3 majority to change something in the Constitution. 2/3. If you have 15 members of Parliament, Madam Chair, then I think that's 10 individuals who can do such. But if we as members of Parliament have an issue with that piece of legislation, with an issue with that piece of Article 50, Madam Chair, then we should caucus amongst ourselves and we should change it. I would want to believe that that's our role, Madam Chair, to change it. So yes, it should go to the Ombudsman, it should go to the Council of Advice, and it should also go to the Council of State. But I also welcome a meeting amongst us, Madam Chair Lady, so that we can discuss it. And we can see whether it's beneficial for St. Martin or not, Madam Chair. Because again, I'm going to go back to the beginning. We adopted a piece of legislation, we adopted an article, inserted in our Constitution because, Madam Chair, the Parliament of Curacao had an issue with an individual that was incarcerated and wanted to come to Parliament to partake in parliamentary proceedings in Curacao. Absolutely nothing to do with St. Martin. Absolutely nothing to do with St. Martin, Madam Chair Lady. But it's in our Constitution today, and we have to deal with it. So yes, Madam Chair, yes, I agree. And I would want it to go to the Council of Advice, the Council of State, the Ombudsman, and also in a committee here in Parliament, Madam Chair. We can discuss it and change it. I thank you very much.
Thank you, MP Emmanuel. The next speakers on the list is MP Peterson. You have the floor.
Thank you, Madam Chair. A good morning still to the honorable members of Parliament, to the griffier and the Secretariat, to those sitting in the tribune, and to all of those tuning in throughout the various media outlets. Madam Chair, a lot on the topic has been said already, but I just wanted to touch base on, some key things to inform the public. First of all, St. Martin is the only island in the kingdom that actually has this article in their constitution. We are talking about Article 50, Section 2. Normally, if you look at the Constitution of Aruba, it's in Chapter 3 of the Constitution where the Parliament is handled. In that chapter, you will see that no corresponding article, as per our Article 50, Section 2, comes forward. If you look at the Constitution for Curacao, in Chapter 4, that's the Staten, there also this article does not come about. So, like my colleague MP Emmanuel said, this was basically a problem that transpired in Curacao, but it is surprising to me that only St. Martin took up a change in their constitution for it. Whether or not that was the right thing to do, that is up for discussion, but it brings about a lot of problems, stuff that I don't think the legislator could have foreseen. For example, Article 44 states that 15 of us represent the people of St. Martin. At the moment, according to Article 50, there's what, 15 and a half, 16? How do we interpret that? If you look at Section 2 of Article 50, the new article that is being debated at the moment, it also, well, actually, if you go to Section 3, it says that not only does MP Baumkamper enjoy his salary, but also that his position wordt waargenomen. to say wordt waargenomen means that somebody is representing you in that position. So therefore, my question also would be to the Council of Advice and maybe even to the legal advisors. What is the role of the acting MP then? Does he have a full MP role and can he make definitive decisions, or wordt het waargenomen for MP Bomkamper? Because like MP Westcott said, we are creating a system now where there's uncertainty as to what the position is of MP Bomkamper. And like MP Emmanuel also mentioned, what if he gets acquitted fully? And I dare to speculate on the law, MP Emmanuel, but I think that is also a reason why they decided to leave him hold his salary up until the verdict. You know, and while I'm speculating on that, that is the only logic that I can think of. And so when it comes to this, I definitely think that we need to look for the right instances, entities to give us advice on it. Not only the Council of Advice, but I would suggest some staatsrecht hooggeleerden, because this is not a legal issue that I think a law firm should take up. This is the Constitution, and law firms do not really assess the Constitution, and the judges are not allowed to do that either, except at the Constitutional Court. So I would be in favor of sending this to, I would be in favor of sending this to the Council of Advice, but also, like MP Emmanuel said, to the Raad van Staten, to see what the Kingdom High Council of State thinks about this. And that we, as St. Martin, are the only country within the kingdom with this regulation. So if you're in Curacao and you get prosecuted and convicted for these exact same crimes that are mentioned in this in Article 50, Section 1, you will still be in Parliament up until the appeal of your case is decided on. So to that extent, our own Parliament is being duped. Whether or not that's the right thing, again, that is up for the Council of Advice to decide. But yeah, I see the logic in us taking this up. And I'm curious to see what the Council of Advice will say, especially when it comes to the role of the acting MP. Because who's to say that if MP Bomkamper, you know, God's willing, next month gets fully acquitted, will he have to come in and sit in, and will he have to also be part of whatever permanent decisions that have been made in his name? Because as you know, his role is being waargenomen. I think that that's where the clarity for me really comes into play. And that'll be all from me, Madam Chair.
Thank you, MP Peterson. I see that MP Westcott Williams would like to have the floor once more.
Yes,
MP Westcott.
thank you, Madam Chair Lady. Madam Chair Lady, the point that I wanted to stress now would have been the one brought forward, at least one of them brought forward by MP Peterson, namely the matter of deputizing. While that states, as MP Peterson correctly stated, the position wordt waargenomen, and we often translate that to mean deputizing, and the question would be, what does that mean in terms of Parliament, in terms of Parliament decisions? There's nowhere in the Constitution where any furtherance is given to that. Madam Chair Lady, it is not as cut and dry regarding it being done because of a Curacao case as put forward in the letter by suspended MP Bomkamper. It's not as cut and dry as that. Yes, that matter played out. However, the crux of the discussion at the time was what happens if a member of Parliament, generally speaking, what happens if a member of Parliament is either arrested, because remember that's also part of it, or convicted in first or second instance, but not irrevocably sentenced yet. That was the discussion. Where and how would you regulate something like that? The matter of deputizing, while, for example, we see in the cases of the chambers in the Netherlands, deputizing is something that happens, but in the case of a member of Parliament being unavoidably out, a female member of Parliament being pregnant, for example, the possibility, and nothing like that is regulated in our Constitution, where deputizing for someone who is out is concerned. Only this particular matter here. It has a different element if the person has been arrested if the person has been arrested, not convicted of any crime yet, has been arrested, is a suspect, and is not able to appear in Parliament. But in the case, the way the Article 50 works in the case of suspension, it is even if you are not yet irrevocably sentenced that you are suspended, with all of the questions coming into play that several of my colleagues highlighted. And Madam Chair Lady, like I stated in the Electoral Reform Committee meeting, we need to get a understanding in terms of what do we want out of this article, and then decide how we address it. Thank you, Madam Chair Lady.
Thank you, MP Westcott Williams. Next, we have MP Solange Duncan. You have the floor.
Thank you, Madam Chair Lady. Good morning to you. Good morning to my colleagues. A good morning to the people of St. Martin tuned in. I just wanted to also add my 2 cents to the conversation, Madam Chair Lady, and I do agree with my colleagues. So I'm looking at 3 different, don't want to use the word trajectory, 3 trajectories, right? Because the constitutional, I still use it, I have to find a synonym. We have 3 proposals, or 3 different avenues. We have the Constitutional Affairs and Decolonization Committee, in which I chair. I do believe that a political discussion should take place in that committee, not only on Article 50, but like my colleague MPs mentioned, a couple of other, let's say, spin-off issues that should be dealt with. So I do think that a meeting should be scheduled, and I can put in for that meeting, because there are a number of things that need to be dissected. And I believe that each faction's opinion should be put on record on these matters. Then I also agree with this issue or advice being sought from the Council of Advice and also the Advanced Data, if possible. But indeed, I do believe that because there are a number of different issues,